The standard terms, you don't need the staff to sign to say they agree it. As long as you've got evidence that they received it and they accept it, that's fine. If they can sign it, then that's great, but it's not essential. If you want them to opt out, that does need to be signed, and they have to know that they have the right to change their mind and opt back in anytime they like. So that is why that bit is on the back, and it's got the signature underneath it. Obviously, if people do need things that are more complicated, more in-depth, that's going to be on a case-by-case basis. But as an absolute minimum, if you stick to that, if you do end up in front of a tribunal, you're not going to get criticised as long as you've got those basic points covered. Now, there's lots of things that I see people include in contracts that don't really need to be in the contract, even though they need to be dealt with. And that's what I call the basic admin. Things like holiday leave, sick leave, maternity leave. It might be bonus structures. It might be whether or not the office closes over Christmas. Now, the disadvantage of putting them in your contract, apart from the fact that it makes the contract that much longer and more complicated, is you shouldn't change a contract, or it's difficult to change a contract without the other side's consent. So if you suddenly decide to change your holiday leave procedure and you've included it in the contract, if people don't agree to it, if all the employees or even some of the employees object to the change, they could potentially argue unfair constructive dismissal. So what I suggest, and what a lot of people do, is they have what we call a handbook. Now, a handbook can just be a few bits of paper. It can be a fairly lengthy document, depending on the size of your business. And because it's a manual and not part of the contract, it's something that you can update as things change. As a company grows, as you need to develop more sophisticated procedures for things like holiday leave, you can just update your handbook without having to have everybody's consent. And it's less admin. It's something that you can have accessible on a directory that everybody has access to, and you can just email everyone round and say, we have updated the handbook, please be aware of the following changes. I've highlighted sick leave and holiday leave procedures as the two main areas where employers often come unstuck, because they are the most controversial issues. Taking holiday leave, being off sick, are the places where people are most likely to fall out. And I find it most common where you have small companies that have grown, because when it's only you and the dog, you don't need a holiday leave procedure, and then you take on one person and you have some casual arrangement. 10 years down the line, when there's 50 people and they all want to have Christmas off, that's when you're going to have a problem. So a good holiday leave procedure is always going to stand you in good stead. It is one of those things that you can develop as things go along. You don't have to stick with what you started. You don't have to stick with what you've got. You do have the right to be flexible. So if somebody is supposed to give 14 days notice that they're going to take a holiday and they only give 13 days, you have the right to say, okay, I can exercise a discretion, I can let you take your holiday. But if you're going to do that, you have to make sure you exercise it across the board. If you've got a reason to give that person a discretion, you have to make sure that if anybody is in similar circumstances, they get the discretion too. Otherwise, you might have a claim for discrimination. So the important thing is always to make a note of why you exercised a discretion in that case, and more importantly, if you don't exercise a discretion, why you haven't. Because otherwise you run the risk that 6 months down the line, somebody is going to say, well, you didn't give me holiday leave, and you didn't give me a bonus, and you didn't do this, and you didn't do that, and if you can't justify it, you are much more likely to have a claim. The holiday leave procedure that I've put in is something fairly standard, but everyone can adapt it to meet their circumstances. I do often recommend that people have a form that people fill in so that you have a record of what they've asked for and how they've asked for it. It makes it much easier to keep the records up to date. Sick leave is another flashpoint. I tend to find that sick leave causes a problem not for those that are off sick, but those that are left behind. Why are we doing all the work when somebody has been off for 6 months? What are you doing about it? Well, again, if you can show that you have a procedure and you are going through the procedure and you are exercising it fairly and reasonably, then you're much less likely to have people being able to say that somebody is being off much more than they should be. It also helps you if you're dealing with somebody who's on long-term sick, if you have a set procedure about how you deal with it and how they are responsible for keeping you informed of what's going on, then it's much less likely that they can complain about things like a breach of confidentiality. If they know what their obligations are to provide you with details of their ability to return to work, and you're relying on a procedure, then you're going to get much better protection. Now, disciplinary procedures we can divide into two sections, which is misconduct and poor performance. Misconduct is things like being off sick when you shouldn't, failure to follow instructions, poor timekeeping. Poor performance obviously applies more to things like salesmen, where they're literally not meeting their targets. Again, what I've set down is just an outline of how it should work. It is a good idea if you have a policy on how issues of conduct and performance will be dealt with. For example, there is a degree of flexibility as to how many warnings you can say somebody has to have before you can dismiss them. ACAS normally recommends at least 2 warnings, but it might depend on the severity. You can have an ability to summarily dismiss people for gross misconduct, but you can define what you consider to be gross misconduct. And as long as your process is reasonable, it will be upheld by a tribunal. I would say that gross misconduct forms part of your misconduct process because you've still got to go through the process. The difference is that if it's misconduct, you might only get a warning. But if it's gross misconduct, having gone through the same process and reached a gross misconduct decision, you have the right to summarily dismiss without giving notice, even if the contract says otherwise. So defining what you consider to be gross misconduct is always a safe thing to do, because then somebody can't say afterwards, well, I didn't realise that doing that is likely to lead to my dismissal. I have seen disciplinary processes be gone through but not be gone through properly, and therefore be found to be automatically unfair. If you go through the process properly and fairly and give the employee every opportunity to explain themselves and to know what the process is, you are much less likely to be found liable for an unfair dismissal claim. And when you bear in mind that an unfair dismissal claim is currently capped at around £72,000 and about to go up to £74,000, there's a lot of money to be taking a chance with, whereas for the sake of going through a process that might take a week or two, and you might be obliged to pay the employee whilst you go through that process, but if at the end of that process you can justify a dismissal, you're going to be saving yourself an awful lot of money. So it does make a difference. The poor performance process is very similar. The difference is that you should be able to show that you are encouraging the employee to improve. You're not looking to dismiss them. What you want is for them to do better, but to set it up so that if they don't do better, you have the right to dismiss them, because the last thing you want is a member of staff who's not performing. You don't want to be keeping them on. I haven't done a handout on redundancy, but it's big news at the moment. Everybody's trying to make cutbacks. Everybody is trying to save themselves money by making people redundant. There are 2 ways in which they come unstuck. One is that they fail to take into account that you shouldn't start with redundancies. If you need to make cutbacks, you should be looking at other things. Where else can we save money? Can we reduce our overheads in any other way? Are there assets that we can be selling? Are there premises we can get rid of? You should only consider redundancy as a last resort. The second place where they come unstuck is unfair selection process. And I often have people come in and say, well, yes, we wanted to get rid of this person and this person, so we designed the criteria to pick those people out. If the tribunal realises that that's what you've done, it will be found to be unfair. And again, you're back to £72,000, £74,000. Okay, it's a maximum, but it's a difficult market out there, and if somebody can't find another job relatively easily, you could be looking at that amount of money. So again, to go through the process properly, you can be saving yourselves an awful lot of money. I know it's a little bit of a whistle-stop tour through employment law, but it is a very simple process. If you follow the procedures, if you keep notes of what you're doing, and if you can show that you acted reasonably, even if a tribunal might have reached a different decision, as long as they can see that your decision was reasonable through your thought process, they will almost certainly uphold your decision and the claim against you will fail.